All right, so this is literally legally legally noirette or legally raven haired on the go, because we are actually recording this video from the cell phone. So hopefully I'm actually sharing the screen like I think that I am. Excuse me, I had some Chester Flamin' Hot fries. Gift from a friend, took me back to my childhood. They were great, but because of that, I have a little bit of a cough going on. So you have to excuse me. It is not any type of communicable disease. All right, so let's get started with part 2 for today. We're going to talk about discovery tactics. So why do you think lawyers view disposition as the most effective discovery device available? Right? Why do they think that? Well, it's because disposition testimony is taken under oath. It puts a witness on the record in advance of trial. It allows counsel to ask a series of questions to follow up on prior answers. The answer will also be spontaneous. The witness is required to reply immediately without coaching from her attorney. A deposition also allows counsel to see the witness in person, probably for the only time before a trial, and judge the impression she will make at trial. Tactically, a witness's demeanor and credibility may be as important as what the witness says. So that's something we want to know. So let's look at that. Why do they like this? Let's just do a little, puts the witness on trial in advance. All right, can we highlight? Yes, we can. Sorry, I'm shaking. All right. Puts them on the record in advance. All right. And also you see the witness's demeanor and credibility, because that's just as important as what they say. All right. So we want to take that into account too. Sorry for the shaking. The main drawback of depositions is that they are expensive. The court reporter will charge a substantial fee, and the attorneys will charge for their time to prepare for and take the deposition. Sorry if I keep saying the wrong word. There are other discovery devices as well. Rule 35 authorizes parties to conduct a medical examination of a party whose physical or mental condition is at issue in the lawsuit. Unlike the other discovery tools, so let's do Rule 35. These are all rules that we want to do videos on, so look for those in the near future. All right, so Rule 35 authorizes parties to conduct medical examinations of a party whose physical or mental condition is at the issue of the lawsuit. Unlike other discovery tools, medical exams require a court order because they are uniquely intrusive on a party's privacy. So parties may also send requests for admission to other parties, asking them to admit facts about the issues in the case or the authenticity of documents. Such admissions can narrow the issues litigated at the trial, since issues agreed upon by the parties need not be proved. So here we have it. So in the discovery, the United States is different in that go at it, right? But here we go, Rule 35 medical examination, because I mean, it's very intrusive. Therefore, the court does have to, give you permission to do that or authorize you to do it. Or how did they say a court order? All right, so you need a court order for a medical exam. And I mean, that just makes good sense, right? I mean, I would want that. During the discovery phase, counsel will also prepare their cases through other means of investigation as well. They will talk to their client, the client's employees, and witnesses willing to be interviewed. They will gather documents. They may use the internet, Freedom of Information Act requests, private investigators, and any other means they have to learn all they can about the facts. They will also research the legal issues likely to arise and prepare memos and briefs supporting their positions. They will frequently hire experts to help them understand technical issues in the case, and often to testify and try as well. So, a distasteful discovery. This sounds interesting. Zucker went to a popular restaurant, Goliath, and ordered seafood. It didn't taste right, as he reported to the waiter. 4 hours later, he became violently ill. Goliath's manager learned of Zucker's illness the next morning and had the 3 chefs from the night before fill out routine incident reports. 2 of the reports, which Goliath regards as confidential, state that the kitchen was very busy and they think one of the cooks may not have properly prepared the fish during the evening. Lab tests confirmed that Zucker had food poisoning. He sues Goliath for negligence in causing his illness. During the discovery phase, Goliath's lawyer schedules a deposition of Riordan, one of the chefs, to ask her testimony under oath. She also requests that Goliath produce for inspection any reports that were done of the incident that night or afterwards. Must Reardon give her testimony at the deposition? Must Goliath produce the incident reports? These discovery requests are clearly within the scope of discovery since the testimony and documents are relevant to Zucker's food poisoning claim. Yet Goliath's counsel, and probably, how do you say it, Riordan as well, would clearly prefer to avoid the deposition and protect the incident reports from discovery, since they may reveal information that strongly supports Zucker's case. However, under the discovery rules, Zucker's counsel has the right to depose witnesses with relevant information and to inspect any documents in Goliath's possession that are relevant to the issues of the case. As noted before, there are certain objections parties may make to discovery requests, such as attorney-client privilege or the expense of burdensome discovery requests. However, these do not apply here, nor does the fact that Goliath ordinarily keeps the reports confidential protect them from discovery. Goliath will almost certainly have to produce the documents in response to Zucker's request. So here's the thing, it's pertinent to the request to depose one of the chefs and then to look at these incident reports. They're pertinent. So he can't just say like, no, I keep that private. That would not fall under the things that would allow you not to talk about it, such as attorney-client privilege and things like that. So now let's talk about judicial conferences. Traditionally, judges played a passive role in litigation. The parties prepared their case and the court provided a judge to preside at the trial when they wanted one. If disputes arose during the pretrial phase or parties filed motions in court, a judge would hear the motion or resolve the dispute, but judges did not actively oversee cases during the pretrial stage. In recent decades, judges have become more involved in managing the pretrial litigation process, particularly in federal courts. In federal courts today, cases are assigned to a district court judge when filed. That judge handles all matters in that case from filing to the final judgment. Federal judges actively manage their cases through conferences with counsel for the parties. Often there will be an early scheduling conference to set deadlines for stages in litigation, such as hearing preliminary motions, automatic disclosure, document production and depositions, filing of motions for summary judgment, or amendment of the pleadings. After the conference, the judge will issue case management orders that set deadlines to structure the stages of pretrial litigation. Toward the end of the discovery phase, the judge will likely convene a final pretrial conference, which may cover any matters relevant to planning the trial. These include defining the issues in the dispute, approving exhibits, resolving challenges to the admissibility of evidence, determining what witnesses will testify, exploring the possibility of settlement, resolving pending motions, and ordering the presentation of evidence at the trial. After the final pretrial conference, the judge will issue a final pretrial order resolving issues concerning trial procedures and setting the stage for presentation of the case to the jury. So in this final pretrial conference, they will discover any relevant matters, issues in dispute, approving exhibits, resolving challenges to the admissibility of evidence, determining what witnesses will testify, exploring the possibility of settlement, resolving pending motions, and ordering the presentation of evidence at the trial. After the final pretrial conference, the judge will issue the final pretrial order. I think that's sometimes called PTO, I could be wrong, resolving issues concerning trial procedures and setting the stage for presentation of the case to the jury, excuse me. Okay, motions for summary judgment. I was just gonna say, I don't know what that means, and here we have it. As noted above, cases may come to an early end on a motion to dismiss for failure to state a claim. Others are litigated through the discovery phase, but still do not end up going to trial if discovery reveals that a party does not have evidence to establish a fact that is essential to recovery. In such cases, the opposing party may move for summary judgment. Here's an example, a case for summary judgment. Ortega sues Acme Company for negligence of Pitvolsky, an Acme employee who drove into her on Main Street. Ortega alleges that Acme is liable for Pitvolsky negligent driving because Pitvolsky acted in the scope of his employment for Acme at the time of the accident. Acme's lawyers know that Acme could be liable under negligence law if Pitvolsky caused the accident while acting in the scope of employment. Thus, they cannot get the case dismissed for failure to state a claim. Acme would be liable if Ortega proved the allegations of her complaint. However, Acme is confident that Ortega cannot prove that Pitvolsky acted in the scope of employment. Acme has clear evidence, Pitvolsky's time cards, and an affidavit from his supervisor that he was not working on the day of the accident. This evidence, Acme's lawyers conclude, clearly shows that Potofsky was not on the job at the time of the accident, unless Ortega can cast doubt on this evidence or provide contradictory proof. Acme must win, since it is not liable for Potofsky's negligence if he was not on the job at the time of the accident. Why have a trial, Acme argues, if the uncontradicted evidence shows that Ortega cannot prove a fact she must prove to recover? My evidence shows that Ortega cannot prove the scope of employment allegation. Acme moves for summary judgment and submits this evidence to the court in support of his motion. What should the court choose? So Ortega is back at it again. First, they wanted Potofsky when they were on the way to the movies. Now they're saying, okay, this day Potofsky was at work. Does Potofsky ever at work? I don't know. So Acme's motion challenges Ortega to show that there is a genuine dispute concerning whether Potofsky was acting in the scope of employment when he had the accident. To do that, she must produce some evidence contradicting Acme's. The court will allow Ortega to submit opposing evidence to show that Potofsky was acting in the scope of employment at the time of the accident. For example, Ortega might submit her affidavit swearing that the truck Potofsky was driving at the time of the accident was full of Acme's products. Maybe Ortega can testify that she heard him say, "I'm so sorry, I was in a hurry to finish my deliveries for the day." Wouldn't Ortega's lawyer love to have that testimony? If Ortega produces evidence contradicting Acme's, it will show that there is a dispute about the issue, which should be resolved at trial. Summary judgment should be denied. However, if Ortega cannot produce contradictory evidence, presumably because Ortega really wasn't working at the time of the accident, it becomes clear that Ortega cannot prove a fact that she must establish to recover. Thus, Acme is entitled to judgment as a matter of law, and the court may grant summary judgment for Acme. The judgment is summary because it is issued by the judge without a trial. So summary judgment is a judgment that is issued by a judge without a trial. So let's see if we can we highlight it? Yeah. All right. Trial. Students often know more about trials than other aspects of civil procedure because of depictions of trials in the media. You may not realize, however, that the right to trial by jury does not apply to many types of civil cases. If the parties are not entitled to a jury trial, the case will be tried before a judge called a bench trial, and the judge will decide both the factual and legal issues. Even if there is a right to a jury trial, parties may waive the right for tactical reasons, choosing to try the case before the judge instead. If a case is tried to a jury, the first step will be to choose the jury through a process called voir dire, in which prospective jurors are questioned by the judge or counsel for the parties to assure that they are impartial. Once the jury is chosen, parties typically make opening statements setting forth the proof they expect to submit. The plaintiff then calls and examines her witnesses and submits documents and exhibits. The defendant's counsel may cross-examine the witnesses after the plaintiff completes her case. The defendant calls and examines his witnesses subject to cross-examination by the plaintiff's counsel. All questioning is confined by strict rules of evidence, which you will study in the upper level course in evidence rather than in civil procedure. Once the parties have submitted their evidence, including any rebuttal witnesses, each party will make a closing statement summarizing her case and arguing why the evidence supports a verdict in her favor. So let me do this. So I remember that we need to get a book about evidence so we can understand what evidence is all about. How about that? All right, let me see. Sorry for the shaking. All right. Once the parties have submitted their evidence, including any rebuttal witnesses, each party will make a closing statement summarizing her case and arguing why the evidence supports a verdict in her favor. A party may move at this point for a judgment as a matter of law, arguing that the opponent's evidence on some element of the claim or defense is too weak to allow a verdict in the opponent's favor. If the motion is denied, the judge will then instruct the jury on the legal rules they must apply to the case. For example, in a contract case, the judge would explain the elements a plaintiff must prove to recover for breach of contract. The judge will also explain to the jurors how they should consider the evidence, who has the burden of proof on which issues, and how the jury should record their verdict on the verdict form. The jury then deliberates and reaches a verdict. A party may move at this point for a judgment as a matter of law, arguing that the opponent's evidence on some element of the claim or defense is too weak to allow a verdict in the opponent's favor. If the motion is denied, the judge will then instruct the jury. Okay, so before the judge instructs the jury. Someone can say, I move for a judgment as a matter of law, arguing that the opponent's evidence on some element of the claim or defense is too weak to allow a verdict in the opponent's favor. If the motion is denied, the judge will then instruct the jury on the legal rules they must apply in the case. So, civil procedure course touches on some procedure matters relevant to trial, including motions for judgment as a matter of law and for a new trial. However, detailed study of the trial process is deferred to the upper level course in trial practice. So once again, civil procedure course touches on some procedure matters, but upper level trial course, just like the upper level evidence course, will really get down to the nitty gritty. All right, so we're just covering the basics here. If we want to get down to the nitty gritty, we got to do the upper level learning. We're not there yet. Okay. Uh-oh. Okay, perfect. Post-trial motions. Even when a case has been tried and the jury has rendered its verdict, the case is not over. The losing party may make several motions to forestall entry of the judgment against her. She may move for a new trial, a do-over, arguing that the first trial was unfair due to erroneous rulings, improper argument, or other problems. She might seek a new trial on the ground that the jury's verdict was so clearly wrong that it represents a miscarriage of justice. She might also move again for judgment as a matter of law, contending that the jury's verdict for her opponent is not rationally supported by the evidence, so that the judge should enter judgment for her instead. As we will see, the judge has the authority to grant such motions in appropriate cases. So she can say, okay, she may move for a new trial, a do-over, arguing that the first trial was unfair or other problems. So let's, the jury's verdict was so clearly wrong that it represents a miscarriage of justice. She may move again for a judgment as a matter of law, contending that the jury's verdict for her opponent was not rationally supported by evidence, so that the judge should enter judgment for her instead. As we will see, the judge has the authority to grant such. Okay, so let's call it. She can ask again for a judgment as a matter of law. And then she can also ask for a do-over or a new trial. Sorry about all the shaking. Okay, just trying to highlight this. Sorry. It's difficult to do it on the phone. All right, perfect. Now, here we have it. So when all post-trial motions have been resolved, the judge will order entry of judgment on the verdict. It is this ministerial act of entering a notion of final judgment on the court docket that officially ends the case in the federal district court. So entry of judgment happens. And then that officially ends the case in federal district court. So now, you don't like it, so you want to appeal. How does that work? Let's find out. Entry of judgment usually ends. Okay. Entry of judgment usually ends the case. However, a losing party may file an appeal if he is convinced that some legal error at or before trial prejudiced his right to present his case fully to the trial court. Typically, appeals must be filed within a short period of time, often 30 days after entry of judgment. So parties will know if the case is over or will go to the appellate court for review. If an appeal is filed, the appeal may automatically stay, postpone the right to collect the judgment, or the party asking the appeal may ask the court to stay enforcement proceedings until the appeal is resolved. It may automatically postpone, or they can ask for it to postpone. The limited role of appeals. Can't do it. The limited role of appeals. If a party appeals and that if a party appeals, is the case retrial in the appellate court? No. Appellate courts do not retry cases or take further evidence. Their role is to review claims that an error of law was made in processing the case at the trial level based on a review of the course of the proceedings below. Parties have a right to have their cases handled fairly by the trial court and decided under the right rules of law. Appellate courts are there to assure that the process was fair and that the law correctly applied the law in the trial court. If a party feels it's the case, retrial. So it's not retrial. Okay, you just. Except in unusual circumstances, they do not second guess the factual findings of the judge or the jury. For example, the appellate court would consider whether the jury was given the wrong instruction on the meaning of negligence or whether the trial judge excluded evidence that should have been admitted. It would not usually reconsider the jury's factual findings, such as whether the defendant drove negligently at the time of an accident. Such factual questions are generally for the trier of fact, not issues for appeal. Appeals are typically heard by a panel of 3 to 7 appellate judges. The panel will review the appellant's claim of error based on a record of the proceedings below, prepared by the parties. This written record, sometimes called the record appendix, will include documents submitted to the trial court relevant to the issues on appeals, such as pleadings, motions, exhibits, briefs, and transcripts of evidence and argument. The appellant will submit a brief stating the issues on appeal, the mistakes she claims were made in the trial court, and arguing why those mistakes support her claim for a reversal of the adverse judgment rendered by the trial court. The appellee, the party who won below and opposes the appeal, will file a brief arguing that the trial court ruling were proper so that its judgment should be affirmed. The procedure on appeal. Appellate courts almost never retry the factual issues in a case. Witnesses do not appear and no new testimony is taken. The appellate court decides the appeal based on a written record showing what happened below. An appeal asserts that some legal mistake was made in the trial court that prevented a fair resolution of the case in that court. The lawyers for the parties argue the issue on appeal in briefs filed in the appellate court, and often, but not always, at oral argument before a panel of appellate judges, as shown here in this picture, reprinted with permission of the Daily Hampshire Gazette. Okay. An appeal asserts that some legal mistake was made in the trial court that prevented a fair resolution of the case in that court. The lawyers for the parties argue the issues on appeal in briefs filed in the appellate court, and often, but not always, at oral argument before a panel of appellate judges, as shown here. The panel will then confer, determine how the issue should be decided, and issue an opinion that both resolves the appeal and explains the governing law. If the court concludes that an error was made in a trial court, it may remand the case to that court to reconsider or retry. So the appellate court just decides, was the law followed? If they say that an error was made, then it will be remanded to the court to reconsider or retry. So appellate courts don't retry the same case. It's done in attorneys argue in briefs. Not always, but usually there is an oral argument. One of the things that we talked about recently in a video was the importance of good persuasive writing, because oral arguments, 30 minutes at best, 1 or 2 issues with questions from the judges. And so the brief is where you really have an opportunity. A lot of judges have already decided what they're going to do before they get there. So appellate courts will hear oral argument from counsel for the parties in many cases, but need not if they believe it unnecessary in particular cases. After argument, the panel will meet and decide how the appeal should be resolved. One member of the panel will be designated to write an opinion explaining the appellate court's decision. The judge will draft an opinion and circulate it to the other judges on the panel. If they all agree on the opinion, it will be issued, delivered to the parties, and often published in a court reporter. If one or more members of the panel do not agree with the outcome favored by the majority, they will file a dissenting opinion setting forth their view as to how the case should be resolved. Most of the opinions you read in law school case books are appellate opinions. This gives a distorted view of civil litigation since only a small minority of trial court decisions are appealed. These opinions reflect only the tip of the litigation iceberg. The effect of a judgment on later litigation. Litigation is a strenuous and expensive business. Few litigants would want to do it more often than necessary. Courts have developed some interesting rules to prevent parties from relitigating a case that has already been litigated and decided. The doctrine of claim preclusion, also called res justica, bars a party who has sued a defendant on a claim from suing that defendant again on the same claim if the first case was decided after a full opportunity to reach the merits. Two bites at the apple. Merkel sues Rico for personal injuries she suffered in an auto accident with Rico in June 2016. Could she later sue Rico in a new suit for damage to her car in the same accident? I think so, because one time she sued for personal injury, this time she's suing for her car. Today, most courts would preclude Merkel's second suit because both the personal injury and the property damages arose out of the same occurrence. Okay, I was wrong. Claim preclusion would bar the section action because Merkel already sued Rico for the accident and is not entitled to a second bite at the apple. All right, so apples and oranges. Could Merkel bring a later action against Rico for injuries in a different accident they had in 2015? Yes. While both Merkel's claims are accident claims, they arose out of different occurrences at different times. Why does Merkel keep riding with Rico? The fact that she sued Rico for one accident does not bar her from bringing a separate action against Rico for another. Issue preclusion distinguished. Sometimes parties litigate and resolve an issue in one case that arises again in a later case. This situation implicates another preclusion principle called issue preclusion or collateral estoppel. This principle usually precludes parties from relitigating issues that were litigated, decided, and necessary to the judgment in a prior action between the parties. For example, suppose that Jane wants to sublet her apartment for the summer, but Stamsky, her landlord, sues Jane, arguing that her lease does not allow her to sublet. The court holds that the lease gives her the right to sublet. The next summer, she decides to sublet again, and Stamsky sues again, arguing the same provision in the lease bars her from subletting. Will Stamsky be precluded from relitigating the issue? The second case is not barred by claim preclusion because it arises out of a new fact that had not taken place when Stamsky sued Jane the first time, but issue preclusion will probably bar Stamsky from relitigating the meaning of the lease provision. This issue is the same one that was litigated and decided in the first case. Why should a court allow them to relitigate the issue if it was fairly decided in the prior action? It could waste the parties and the court's resources to go through this second time. Caution, don't be intimidated by this quick romp through the phases of a lawsuit. This overview is meant to give you a sense of the scope of the litigation process so that you can place issues in context as we study them. Later chapters will cover each of these concepts in detail. Sources of civil procedure, regulation, constitution, statutes, and rules. The materials you study in civil procedure include a good many rules, statutes, and other provisions of law that regulate the process of litigation. This section explains where these come from, who enacted them, and how they relate to each other. First, consider the types of regulations that govern procedure in the federal courts. The United States Constitution. Certain aspects of civil procedure in federal courts is governed by the provisions of the U.S. Constitution, which establishes the basic framework of our federal government. For example, Article 3 includes basic provisions governing the structure and jurisdiction of the federal courts. Article 1, Section 8, Clause 18 authorizes Congress to make laws necessary and proper to implement the federal judicial power. The 5th and 14th Amendments guarantee parties due process before a court can deprive them of life, liberty, or property. The 6th Amendment guarantees a jury trial, a right to counsel, and other rights in federal criminal cases. The 7th Amendment guarantees the right to jury trial in some civil cases in federal courts. Federal statutes governing procedure in federal courts. Pursuant to Article 1, Section 8, Clause 18 of the Constitution, the necessary and proper clause, Congress enacts statutes and regulate many aspects of the procedure in federal courts. Many of these statutes governing federal court procedure are published in Title 28 of the United States Code. Some of these statutes are included in your rule supplement, but only some. So there are frequently gaps in numbering. Here are some examples of statutes that govern various aspects of federal practice. Okay, Section 133, appointment and number of federal judges. Sections 1251 to 1257, jurisdiction of the United States Supreme Court. Section 1291 to 1296, jurisdiction of the Federal Court of Appeals. Section 1331 to 1369, jurisdiction of the Federal District Court. Section 1441 to 1454, removal of cases from state to federal court. We just did a video on that last week. And then Section 1861 to 1875, jury selection in federal cases. The statutes Congress enacts under its constitutional powers cannot contradict the United States Constitution, which by its terms is the supreme law of the land. The U.S. Constitution, Article 6, Section 2. For example, the 7th Amendment guarantees jury trial in certain civil cases, so Congress could not enact a statute barring jury trial in these cases, but Congress may enact statutes pursuant to the necessary and proper clause to regulate procedure in the federal courts in ways consistent with the Constitution. The Constitution establishes the broad outlines of the federal court system. Congress regulates the particulars of practice and procedure in the federal court by statute. For example, the statute cited above, 28 United States Code, Section 1861 to 1875, set forth procedures for implementing the right to jury trial and thus are consistent with that constitutional right. The Federal Rules of Civil Procedure is the next thing. In addition to the federal statutes governing federal court practice, Congress has delegated the United States Supreme Court the power to enact court rules governing matters of procedure in federal courts that are not prescribed by statute. See 28 United States Code, Section 2071 to 2077, the Rules Enabling Act. The Rules Enabling Act authorizes the Supreme Court to adopt general rules for practice in the federal district courts and the Court of Appeals. The court, in turn, has delegated rulemaking to the Judicial Conference of the United States, whose advisory committee on civil rules, composed of lawyers, judges, law professors, does the actual work of drafting and recommending rule changes, which is why the advisory committee notes are sometimes cited as legislative history. The advisory committee's recommendations for the changes pass through the Judicial Conference to the Supreme Court, and if the court approves the changes, they are submitted to Congress no later than May 1st of each year. Unless Congress modifies or rejects the rule changes, they become effective on December 1st. The basic process has been in place since the Supreme Court adopted the Federal Rules of Civil Procedure in 1938. The federal rules, which you will study closely in civil procedure, govern many aspects of day-to-day practice in the district courts that are not governed by statute or by constitution. Because the court adopted the federal rules pursuant to delegation of authority from Congress, the rules have the force of law in effect. Congress has authorized the court to write the detailed laws governing practice in the federal trial courts. If you thumb through the federal rules, you will see that they regulate the entire process described in the first half of this chapter, including filing suit, pleadings, pre-answer and other motions, judicial conferences, discovery, conduct of trial, post-trial motions, and enforcement of judgments. The order of the rules generally reflects these stages of a lawsuit. Early rules deal with the issues such as pleadings and service of process, middle rules with discovery, and later rules with trial and post-trial procedure. Local rules of federal district courts. There is yet another level of lawmaking in the federal courts. Federal Rule 83 authorizes judges of each federal district court to adopt local rules to govern the details of practice in that district. Such local rules may be consistent with the Federal Rules of Civil Procedure, federal statutes, and constitutional provision. Local rules govern many details of practice not prescribed by the federal rules, federal statutes, and constitution. For example, a district local rules may govern details of district court practice, such as the time for filing briefs, impoundment of private material in civil cases, the form of discovery requests, conduct of scheduling conferences, assignment of cases, continuances, postponements of hearings, or trials, electronic filing of documents, and many other aspects of practice. Although you will become familiar with the local rules of the federal district and your state, when you enter practice, local rules will not be covered in detail in your civil procedure class. The hierarchy of types of legal regulation portrayed in Figure 2.2 below. In pleading cases that analyze constitutional provision, statute and rules applicable to the federal courts keep this hierarchy of authority in mind, and the basic principle that a regulation at each level may supplement but not contradict sources of regulation above its hierarchy. Here's an example of how these levels of procedure regulation might apply to a single case. The Seventh Amendment to the United States Constitution guarantees the right to a jury trial in many cases, in many civil cases in the federal courts. Congress could not enact a statute that barred jury trials in those cases, nor could the Supreme Court promulgate a federal rule of civil procedure that called for a different method of trying those cases. Nor could the federal court for the Western District of Washington, to pick a district at random, adopt a local rule calling for a different mode of trial. But federal statutes and rules can govern other aspects of jury trial that are not addressed in the Constitution. For example, Congress has enacted statutes governing qualifications for jurors, an issue not prescribed by the Constitution, but consistent with the Seventh Amendment right. And Rule 38B of the Federal Rules of Civil Procedure, adopted by the Supreme Court pursuant to the Rules Enabling Act, prescribes the proper procedure for demanding a jury trial, an issue not addressed by either the Seventh Amendment or any federal statute. Further, a local rule of the federal district might govern details of calling jurors for jury service or special procedures for claiming a jury trial or examining jurors, details not covered in the Constitution, statutes, or federal rules. See local rules, WD Washington R38B, specifying method of placing demand for jury in a pleading. Confusion, worst confounded. Actually, there is at least one more level of judicial regulation to consider, though it will seldom come in the materials in this book. Individual judges often issue standing orders specifying procedures that they will use in their individual courtrooms. These orders cannot contradict the Constitution rules, the federal rules, or local rules of the district, but they can fill in further intersectices. I'm not sure how you pronounce that. I know what it means. Okay. For example, a judge standing order might specify how potential jurors will be questioned during the voir dire, or when counsel may move to strike a juror, assuming these details are not specified by statute, federal rule, or local rule. So sources of procedure regulations in federal court. So you have the United States Constitution ratified by the states. Federal statutes enacted by Congress must be consistent with constitutional provisions governing the federal courts. Federal rules of civil procedure adopted by the United States Court must be consistent with congressional delegation of authority to regulate procedure in the Rules Enabling Act and with the federal Constitution. And then local rules adopted by individual federal districts. The local rules of the Eastern District of Arkansas must be consistent with the federal rules, federal statutes, and the federal Constitution. And then you have standing orders that the judge can do in their courtroom. Example, sources of procedure regulation. Federal Rule of Civil Procedure 48A provides that a jury shall begin with at least 6 and no more than 12 members, and each juror must participate in the verdict unless excused for good cause. The Federal District Court for the District of Alhambra adopts Local Rule 48.1, which provides that district judges in the District of Alhambra shall impanel juries of 8, including 2 alternate jurors in case a juror is dismissed during trial, and shall dismiss the 2 alternate jurors before the jury deliberates if no other juror has been dismissed. Is the local rule valid? Only in part. Federal Rule of Civil Procedure 83, adopted by the United States Supreme Court under the Rules Enabling Act, provides that local rules must be consistent with the federal rules. The provision of the Alhambra District Court Local Rule 48.1, calling for 8 jurors, is consistent with Rule 48 of the Federal Rules of Civil Procedure because the federal rule allows anywhere from 6 to 12 jurors, but the provision of the local rule calling for dismissal of alternate jurors is not consistent with Federal Rule 48, which provides that all jurors shall participate in the verdict unless excused for cause. This aspect of the local rule is invalid since it contradicts the governing federal rule. Regulation of procedure in the state courts. A similar hierarchy of authorities applies in state courts. Certain guarantees in the United States Constitution apply in the state courts as well as in federal courts, such as the Fifth Amendment right against self-incrimination. Some aspects of state court practice will be governed by the state's constitution, others by state statute, others by court rules promulgated by the legislator of the state's highest court, and others by rules adopted by a particular court, such as the probate court or housing court. Within a state system, here again, lower level rules and regulations must be consistent with higher level state statutes and constitutional provisions. Keep in mind, however, that the federal rules, which you will deal with consistently in civil procedure, do not govern state court procedure. They are federal rules applicable in the federal courts only. Many states, however, have modeled their civil procedure rules on the federal rules. Another reason to study them in civil procedure. As of 1988, 23 states had copied them almost verbatim, and 2/3 of the states based their rules substantially on the federal model. Shreve, Raven, Henson, and Guy, section 102, People's pages 7 through 8. The litigation process, summary of basic principles. Federal litigation commences with the filing and service of pleadings, followed by an intensive phase of automatic disclosure, discovery, motions, and investigation, culminating in a pretrial conference to map out the scope and order of the trial. Cases do not settle, are tried to a jury or to a judge. Litigation in the trial court ends with the entry of a judgment for the prevailing party. Discovery dominates most litigation practice. It is conducted by the lawyers for the parties, but their discovery requests are backed by the enforcement power of the court under the federal rules of governing discovery. Most discovery disputes are worked out by the parties. If they cannot agree, the court will control access to proof through orders to produce evidence or protective orders barring inappropriate requests. Several different layers of legal regulations govern the litigation process in federal courts. Provisions of the United States Constitution set forth broad structural features of the federal courts. Congress has enacted statutes that regulate many additional aspects of federal court procedure, which must be consistent with constitutional provisions. In the Rules Enabling Act, Congress delegated authority to the Supreme Court to regulate procedure in the lower federal courts. The court has adopted the Federal Rules of Civil Procedure. Pursuant to the authority, the rules govern many aspects of pleading, pretrial practice, and trial procedure in the federal courts. The judges within each federal district are authorized under Federal Rule 83, a delegation of the court's delegation to enact local rules governing details of practice in that district. Local rules supplement the Constitution, statutes, and the federal rules in regulating local practice, but cannot contradict those sources of procedure regulation. Here are the notes. The term statute usually refers to an enactment of the highest legislative body in a government. Congress enacts federal statutes. The state legislature of each state enacts the statutes of that state. Okay. How do you pronounce that word again? Analogously, the Court of Appeals are authorized to promulgate additional rules applicable to their circuit court. These rules supplement the federal rules of appellate procedure, the rules for procedure in the Court of Appeals adopted by the Supreme Court. All right, and then this, see. Okay, adding that to the reading list. All right, want to see 28, the U.S. Code, section 1861 to 1866. All right, so this is the end of chapter 2, a description of the litigation process and sources of procedural law, and look for a short video where we talk about the timeline of the typical civil action. I don't know if we can make that bigger, but we're going to do a short video about all of this. So thank you so much for tuning in to Legally Norette, Legally Raven Haired. This is Devaney signing off.